Losing a loved one is undeniably one of life's most difficult moments. As you navigate the profound grief and try to honor their memory, the last thing you want to face is a labyrinth of legal complexities.
Yet, for many families, this is exactly what happens when they enter the probate process. Today, we are going to demystify this often overwhelming system, explore the common delays, and answer the most pressing question: how long does probate really take? When a loved one passes away, you often hear the word probate, but what does it mean? In short, probate is the formal legal process that manages a person's estate after their death. It is the court-supervised procedure of authenticating the deceased's final wishes. Think of probate as a four-step journey. First, the court validates the last will and testament. Next is the asset inventory, where every property and bank account is appraised. Third is debt settlement, ensuring creditors are paid off. Finally, the remaining assets are officially distributed to the rightful beneficiaries. While probate gets a bad reputation, it serves a critical purpose. It provides a legal framework to ensure debts are resolved fairly and assets end up exactly where intended. When people hear the word probate, they often imagine years of endless legal battles, frozen bank accounts, and mountains of stressful paperwork. But in a truly ideal scenario, a straightforward probate case can usually wrap up in just 6 to 12 months. Let us look at how this optimistic timeline breaks down. The process usually begins with filing the initial petition with the court, which happens in the first 1 to 4 weeks. Following this, the executor must notify potential creditors. This mandatory creditor notification period generally lasts from month 2 through month 6. While that clock is ticking, the executor will simultaneously work on identifying and valuing the estate's assets, typically taking place between month 3 and month 7. Finally, if all debts are paid and no disputes arise, the court will approve the final distribution to the heirs between months 6 and 12. While this smooth process is what every family hopes for, it represents the absolute best-case scenario, where paperwork is flawless and everyone is in full agreement. One of the biggest reasons probate drags on is the sheer complexity of the estate itself. If the deceased owned multiple real estate properties across different states, held various business interests, or managed extensive investment portfolios, the court needs time to untangle everything. Assets located overseas can add even more red tape to the process. But it is not just about what is in the estate. Often, it is about what is missing. Unclear documentation is a massive roadblock. This could mean a lost will, undocumented deaths that suddenly surface, or trying to track down heirs and beneficiaries who have moved or lost touch with the family over the years. Every single missing piece requires investigations, legal notices, and waiting periods dictated by state laws. When the executor has to act like a private investigator just to figure out who gets what, or even what exists, months or even years can easily be added to the probate timeline. Another major roadblock that can bring probate to a grinding halt is family disputes. When heirs disagree over the validity of a will, how assets should be distributed, or who should be in charge, the process stalls. Even a single beneficiary contesting the will can drag the timeline out for months or even years, often requiring formal mediation or litigation to resolve. Once lawyers and judges get involved, the estate is at the mercy of the court's calendar. What could have been a simple administrative procedure turns into a lengthy legal battle. Beyond family drama, creditor claims are another common culprit. Before assets can be distributed, the estate must settle its debts. If unexpected or complex claims surface, such as undisclosed personal loans, tangled business debts, or massive medical bills from multiple providers, it takes significant time to verify and pay them off. Sometimes the delay in probate has nothing to do with the estate itself, but rather the system handling it. Overloaded probate courts are a massive bottleneck. High caseloads, chronic staff shortages, and standard administrative delays can turn what should be a quick filing into a months-long waiting game. You might submit everything perfectly, only to wait weeks just to get a hearing date or a judge's signature. On the flip side, delays frequently come from within. The executor of the estate might be a family member who is overwhelmed, inexperienced, or simply lacks the legal understanding required for the job. When an executor struggles with poor organization, misses deadlines, or takes weeks to respond to attorney emails, the entire probate timeline stalls. Even a well-meaning but busy executor can inadvertently add months to the process. If an executor is completely negligent, beneficiaries might even need to petition the court for their removal, causing massive further delays. Consider a family where multiple siblings inherited a sprawling estate without a clear will. What should have been a straightforward transition turned into a 3-year battle over property boundaries and business assets. The emotional weight of this process fractured their relationships, while legal fees quietly consumed a massive portion of the inheritance they were fighting for. In another instance, an elderly widow found herself frozen in the probate process for over 2 years simply because of undiscovered debts and complex tax filings left by her late husband. Meanwhile, the family home she desperately needed to sell sat empty and fell into disrepair. These are not just legal hiccups. They are devastating financial burdens placed on families already navigating the heavy grief of losing a loved one. While some aspects of the probate timeline are out of your control, there are concrete steps you can take to streamline the process and spare your loved ones unnecessary stress. Let's look at a few practical ways to mitigate delays before they happen. First, meticulously organize your important financial and legal documents, both electronically and physically. This allows your executor to hit the ground running. Next, choose your executor wisely. Select someone who is reliable, detail-oriented, and has the capability to manage complex administrative tasks. Ensure your will is drafted clearly to avoid any ambiguity that could lead to disputes among heirs. Finally, don't wait to seek professional advice. Consulting with an experienced estate planning attorney early on can help you navigate complexities and minimize future hurdles. While the timeline for the probate process varies greatly from a few months to several years, it is important to remember that many of the most common delays are entirely preventable with proper planning. By staying prepared, keeping your documents organized, and seeking professional guidance, you can save your family significant time, money, and unnecessary stress. Taking the right steps today ensures that your loved ones can focus on what truly matters, instead of getting bogged down in complicated legal paperwork. For more comprehensive resources, expert guidance, and ongoing support on navigating the probate process, visit funeralus.com. We are here to help you and your family every step of the way. Thank you so much for watching. We hope this video helped you understand how long probate really takes and the steps you can take to avoid unnecessary delays. Navigating estate matters isn't easy, but being informed is your best defense. If you found this guide helpful, please hit the like button and subscribe to our channel for more valuable insights. Have a question? Drop a comment down below. We would love to hear from you. See you next time.